James Seho, circuit judge. So this is the Fifth Circuit Court of Appeals. Petitioners identified as members of Tren de Aragua, a designated foreign terrorist organization, should not be allowed to proceed in this appeal. Our April 18th order held that we lack jurisdiction to grant the relief sought by the petitioners. But last Friday, the Supreme Court reversed our unanimous decision of a 3-judge panel over a vigorous dissent by Justice Alito, joined only by Justice Thomas. As an inferior court, we're duty-bound to follow Supreme Court rulings, whether we agree with them or not. We don't have to like it, but we have to do it. My dad always told me that. You don't have to like it, you just have to do it. So I concur in our order today, expediting our consideration of this matter as directed by the Supreme Court, but I write to state my sincere concerns about how the district judge, as well as the president and other officials, have been treated in this case, the district judge being the lower federal trial court judge. I worry that the disrespect they have been shown will not inspire continued respect for the judiciary. No kidding, without which we cannot long function. It is not the role of the judiciary to check the excesses of the other branches, which is what Chief Justice John Roberts just argued in an interview with the media. He said it's the role of the Supreme Court to check the excesses of the executive branch. That is not the role of the judiciary, as I expect Judge Ho is going to explain here in a moment. The judicial branch is not a third political branch of government. There's 3 branches of government. Only 2 of them are intended by our founders to be political, policy-based in nature. The Article 1 legislative branch, the House and Senate, the Congress, and the Article 2 executive branch. The Article 3 judicial branch is not intended to be a political branch. That's why it's not elected. That's why it's least amenable to correction by the political will of the American people, because it's not supposed to be political. But it has become political. It has become corrupted. Judge Ho, it's not the role of the judiciary to check the excesses of the other branches. Whose role is that? The other branches. The checks and balances, as stated in the Constitution, between the Article 1 legislative branch and the Article 2 executive branch, and by extension, the American people who elect them. We don't elect federal judges. We elect congressmen and senators and presidents. That's how we exercise our political will most directly in a government that's supposed to be of the people, by the people, for the people. Not a tyranny of unelected, black-robed, tyrannical, inferior federal district trial court judges elected by nobody. I get excited about this stuff, folks. Sorry. Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive, adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding, gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you. Back to Judge Ho again. It's not the role of the judiciary to check the excesses of the other branches any more than it's our role to check the excesses of any other American citizen. Judges do not roam the countryside looking for opportunities to chastise government officials for their mistakes. But if you saw the interview, maybe I should cover this in a separate show, of Chief Justice Roberts, and you saw the interview of Sotomayor, and you saw the interview of Kagan, they're all out in public chastising the Article 2 executive branch over policy decisions, over the Article 2 executive branch's exercise of its core and plenary powers under the Constitution, powers assigned by the Constitution exclusively to the political branches of government, particularly when it comes to matters of national security, to the Article 2 executive branch president elected by the whole of the American people, the only office in the United States for which the whole of the American people vote. The Article 2 executive branch president, currently our fantastic, amazing, stupendous Donald Trump. Rather, our job of the judiciary is simply to decide those legal disputes over which Congress has given us jurisdiction. All legal disputes? No. The legal disputes over which Congress has given them jurisdiction. Only the Supreme Court was created by the U.S. Constitution in Article 3. Every court below the Supreme Court, the federal trial courts, meaning the district courts, the circuit courts, the courts of appeal, literally the Constitution refers to these as the inferior federal courts, are creations by Congress, and Congress decides what jurisdiction these courts have. They don't have universal jurisdiction. Their jurisdiction, their legal authority, is limited in terms of the parties before them. It's limited in terms of the subject matter before them. It's limited in terms of the geography over which they have jurisdiction. But you wouldn't know it by listening to these federal courts. They believe they have infinite jurisdiction over everybody on every issue everywhere, even international airspace. Continuing, under 28 U.S.C. 1292A1, appellate courts have jurisdiction to review interlocutory orders of the district courts that refuse to enter an injunction. So an interlocutory order, what we're talking about here is essentially a direct, immediate appeal from a trial court to a court of appeals. You don't have to wait for the end of the trial to appeal to the court of appeals. You can do it immediately when you get a particular kind of order from them. That includes orders that have the practical effect of refusing an injunction. That is demonstrably not this case. The district trial court made amply clear to the terrorists that it stood ready to hear the request for emergency relief. Didn't deny it. The trial court said, I'm going to hear it. Indeed, the court had already ruled on one such request the day before. The court simply advised the terrorists that the government, the Trump administration, would get 24 hours to respond before the trial court would issue a ruling one way or another. In other words, the trial court said, listen, you approached me ex parte by yourself without the other party, opposing party present. By the way, the terrorist lawyers got chastised by the trial court for doing that. That's completely inappropriate. That can justify sanctions and should have against those lawyers. They left voice messages with the trial court without notifying the government. They were seeking a decision from the trial court. And the trial court said, listen, first of all, that's wrong. You're not allowed to do that. That's inappropriate. That violates your ethical duties as attorneys before this court. And second of all, I'm not going to issue a decision unless I hear both sides of the argument. And I'm giving the Trump administration 24 hours, which is not a lot of time, to respond before I issue a ruling one way or the other. So the court's not saying no. The court's saying I need to hear both sides. The court also reminded the terrorists that the government had assured the court that federal officials would not remove petitioners without first giving the court advance notice. So there was no immediate risk of irreparable harm here. So when the terrorists sought relief at 12:34 a.m. on April 18th, the terrorists were fully aware that the trial court intended to give the government 24 hours to file a response. They said nothing about a plan to appeal if the trial court elected to wait for that response, which is what they did. They immediately appealed 12 hours later. On 12:48 p.m. on April 18th, petitioners suddenly informed the trial court, they would file an appeal if the trial court did not act within 42 minutes by 1:30 p.m. So when the trial court, to no one's surprise, couldn't comply with their patently unreasonable timetable, petitioners immediately filed this appeal with the Fifth Circuit Court of Appeals, which is where Judge Ho sits. Our court, the Fifth Circuit Court of Appeals, responded expeditiously. That night, we held that we lacked jurisdiction to hear this appeal. Our April 18th order explained that petitioners gave the court, the trial court, only 42 minutes to act and did not give the government an opportunity to respond. As our distinguished colleague put it, 42 minutes is quite plainly an unreasonable deadline. We cannot find an effective denial of injunctive relief based on the trial court's failure to issue the requested ruling within 42 minutes. So to clarify all this, if the trial court had denied the preliminary injunction, said, no, I'm denying it, then the terrorists could immediately appeal to the Court of Appeals. If the trial court did not explicitly deny the injunction, the request for an injunction, but so much time had passed that it was an effective denial of the injunction, then the terrorists could appeal directly to the Court of Appeals. But when the trial court's given only 42 minutes, there is no effective denial. That's not a reasonable period of time in which the trial court can make that decision, especially when the trial court's already said 12 hours earlier, I'll need 24 hours to give the government a chance to respond. Judge Ho continues, our decision was unanimous because it's obvious. 42 minutes is not remotely enough time to review and analyze all of the relevant legal authorities and prepare a reasoned ruling. So why did the Supreme Court just rule as they did? Is it possible the Supreme Court, the progressive woke DEI justices on the court, are not looking, are not interested in a reasoned ruling? They simply know the outcome they already want. Did any of you join me for my show where I went over the Supreme Court oral argument on the so-called birthright citizenship issue under the 14th Amendment? Did you hear how justice after justice told, constantly interrupting, John Sauer, the Solicitor General of the Article 2 Executive Branch, who's arguing for the Trump White House before the Supreme Court, would ask John Sauer a question, he'd say 5 words, and they would interrupt him. And then they repeatedly told him, well, you're obviously wrong on this question of birthright citizenship. You're just wrong. You're just wrong on the merits. Well, he's not wrong on the merits. He's right on the merits. But the Supreme Court's not interested in hearing the arguments. They've already arrived at their uninformed, politically motivated conclusion on the question of birthright citizenship. Specifically, that it's available to anyone who happens to be born on U.S. soil. That is not what the 14th Amendment says. It's not what the Supreme Court itself has ever said in any of its decisions. Back to this. Notably, the justices themselves have expressed concerns about making decisions under far more forgiving time constraints than those demanded here. Recall the emergency relief in Doe's v. Mills. Members of the Supreme Court expressed concern about the use of the emergency docket to force the Supreme Court to grant extraordinary relief on a short fuse without benefit of a full briefing. That was by Justice Barrett. By the way, guess who wrote the recent Supreme Court decision? Well, they don't tell us. It's per curiam, which means basically the whole court. But it's not really the whole court, is it? Because we had at least two dissents. Alito and Thomas both dissented in that Supreme Court decision. So it wasn't really per curiam. But in that case, and Barrett was in the majority of that decision. So Barrett was among those of the Supreme Court saying, no, we're going to grant this injunction because we believe 42 minutes was enough for the trial court to make a decision. And if they didn't make a decision in 42 minutes, that was an effective denial of the request for a preliminary injunction by these Tren de Aragua terrorists. So this time, Barrett is saying 42 minutes is enough. And if you don't do it in 42 minutes, trial court, if you don't make a decision in 42 minutes, we will deem that to be an effective denial. But in this other case, Justice Barrett wrote that 9 days was not enough to make a decision. So if no decision was made in 9 days, the Supreme Court should not deem that an effective denial. But now when it comes to immigration, 42 minutes is enough to deem it an effective denial of a motion for a preliminary injunction. So the trial court, Judge Ho continues, reasonably assumed that the principle invoked in that prior case to justify denying relief to law-abiding citizens concerned about their religious liberties in the COVID-19 era, which is what that other case was about, would likewise justify denying relief to illegal members of a foreign terrorist organization. If the 9 days was good enough for American citizens, why do terrorists get what they want after only 42 minutes? The trial court was absolutely right then when it noted that issuing a competent and defensible ruling required some level of care. And some level of care takes time, more than 42 minutes. As Justice Alito, who dissented from the Supreme Court decision I just shared, would later note, we should commend this careful approach, not criticize it. Rather than commend the trial court, however, the Supreme Court charged the trial court with inaction, not for 42 minutes, but for 14 hours and 28 minutes, from 1 a.m. in the morning to 1 p.m. in the afternoon. This inaction was, according to the court, tantamount to refusing to rule on the injunction. Remember, the trial court had said, I'll rule within 24 hours, but I'm giving the government 24 hours to tell me their side of the argument. Everybody knew this going in. This inaction was, according to the Supreme Court, a purported inaction by the trial court was, according to the Supreme Court, tantamount to refusing to rule on the injunction. This charge, meaning this accusation thrown at the trial court, is worth exploring. To get to 14 hours and 28 minutes, rather than 42 minutes, the Supreme Court was obviously starting the clock at 12:34 a.m. rather than 12:48 p.m., when the terrorists told the trial court for the first time that they wanted a ruling before the government could respond. But starting the clock at 12:34 a.m. not only ignores the court's express instructions respecting the government's right to respond, it also ignores the fact that the court is starting the clock at 12:34 a.m. We seem to have forgotten that this is a federal district trial court, not a Denny's. This is the first time I've ever heard anyone suggest that district trial court judges have a duty to check their dockets at all hours of the night just in case a party decides to file a motion. If this is going to become the norm, then we should just say so. Trial judges are hereby expected to be available 24 hours a day. And the Judicial Conference of the U.S. and the administrative office of the U.S. courts should secure from Congress the resources and staffing necessary to ensure 24-hour operations in every district court across the country. If this is not to become the norm, then we should admit that this Supreme Court order is special treatment being afforded to certain favored litigants like members of Tren de Aragua, a designated terrorist organization, and we should stop pretending that Lady Justice is blindfolded. In other words, we should just acknowledge that the Article III judicial branch has, all the way up to the Supreme Court, has become explicitly political. Judge Ho continues, I have no problem making clear when a district court has abused its discretion and jeopardized the reputation of the judiciary. But this district judge conducted himself in a reasonable and indeed admirable manner. All inferior court judges, meaning everything below the Supreme Court, expect to be reversed on appeal from time to time. But I'd wager that this judge never imagined he'd be reversed on grounds of laziness. In parentheses now, a brief glance at the docket suggests an extraordinarily diligent judge who somehow found the time to balance the needs of this challenging case, including a number of motions and orders throughout the week, all while presiding over a complex and sensitive criminal trial involving multiple child victims. So any criticism of this district judge, trial judge, is unwarranted and unfortunate. It's no wonder that Justice Alito rejected the Supreme Court's decision as misleading and a mischaracterization of what happened in the trial court. As he put it, the Supreme Court characterizes the trial court's behavior during the period in question as inaction. But in my judgment, that's unfair. The judge was working with utmost diligence to resolve the important and complicated issues presented by the motion as quickly as possible. Moreover, a distinguished former district trial judge has already come forward with these pointed observations. Judge Hendricks's service was exemplary. The majority of the Supreme Court was wrong to malign this judge and send a disturbing message about procedural norms. We need more jurists like Judge Hendricks, and the Supreme Court should think more carefully about how its rulings distort the work of the lower courts. The trial judge is not the only public official whose treatment in this case warrants comment. Recall why the trial court established a 24-hour filing deadline. The trial court firmly believed that the government should have the right to express its views before any ruling is issued. Yes, the courts are an adversarial process. Both sides get to be heard. Our adversarial legal system has long been premised on the notion that judges should impartially consider the views of both sides of any dispute before issuing a ruling. It should go without saying that the president and his fellow executive branch officials deserve the same respect that courts regularly afford every other litigant, every normal plaintiff, including other presidents and officials. One former president tried to shame members of the Supreme Court during a State of the Union address by disparaging a recent ruling. Guess who that was, folks? Remember that? That same president, Barack Obama, also suggested it would be illegitimate for the Supreme Court to declare an act of Congress unconstitutional, while a case challenging his signature legislative achievement, Obamacare, was pending before the Supreme Court. Another former president was disbarred from practicing law before the Supreme Court. That, of course, is Bill Clinton, because he lied before the Supreme Court. Yet I doubt that any court would deny any of those presidents the right to express their views in any pending case in which they are a party before issuing any ruling. Our current president deserves the same respect. Guess who else gets due process? MFers? President Trump. This appeal should be over. The terrorists denied the trial court the opportunity to rule on their emergency motion in the first place. That alone should be enough to terminate this appeal. But the Supreme Court has reversed our unanimous judgment, so this appeal must now proceed. I accordingly concur. You think he's really concurring? This is listed as a concurrence. Judge James Ho, everything I just read you, concurring. He's concurring with the outcome. He's an inferior federal circuit court, district court judge, circuit court judge, court of appeals. So he's compelled by the Constitution to follow the orders of the Supreme Court. So he can't say no. So he's not saying no. He's saying, I concur. And this is bull poop. This is bull poop, Supreme Court. Our nation deserves better. And I agree 100% with Judge Ho. Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.